welcome to The Firm. On the show this week, is India's anti-sexual harassment bill worth the 15-year wait? And why the US Securities Exchange Commission, or the SEC, looks a lot like CSI Washington these days. India is just one signature away from a new law on the prevention, prohibition and redressal of sexual harassment of women at the workplace. It's been a 15-year-long wait. In the absence of a law, the Supreme Court of India laid down comprehensive guidelines in the landmark Vishakha case judgment in 1997. But as we've discovered, not even the apex court has followed its own directions. The need for a law, then, has been keenly felt as more women join the workplace in India. And though the bill has been pending for more than 5 years, its passage through Parliament picked up pace only after the horrific Delhi rape last year. So, has the 15-year wait been worth it? Payaswini Upadhyay finds out.
8,570 cases of sexual harassment were reported in India in 2011. That's to the police. The unreported cases in workplaces across the country are likely to be many times that. To facilitate the reporting of sexual harassment complaints, the new law mandates the creation of committees with a majority of women and at least one woman NGO member. The 1997 Supreme Court Vishakha judgment included a similar requirement, but the lack of compliance is evident in that the apex court itself has not constituted such a committee to date.
There was a case of sexual harassment in the Delhi High Court, an appeal of which had come up in the Supreme Court. And the ladies of the Supreme Court, the working lawyers in the Supreme Court felt that it was time that some redressal system is set up in the court premises also. So about 63 ladies have filed an intervention application in this particular case of this particular lady. And we are seeking a setting up of a committee to address this problem.
Now, all employers in the organized sector, whether courts, companies, hospitals, educational institutes or government departments, will have to constitute such internal complaints committee at all administrative units or offices. Leading IT company Infosys constituted an internal complaints committee in 1999. 2 years after the Vishakha judgment and 2 years before it faced a high-profile sexual harassment lawsuit that led to the sacking of its head of sales and marketing, Panish Murthy. The company says it regained face value quickly only because it had systems in place, systems it has since strengthened.
I think us formalizing this as a policy was important because you're absolutely right that sometimes in companies management believes it is important, but it doesn't naturally cascade into the junior levels. But when you introduce it as a formal policy, then not abiding by a policy by itself has a consequence, which is why employees take it very seriously. But beyond the policy part is the actual practice of what it means. So the education part to employees, both men and women, as to what this policy would mean in terms of its effect. So what are behaviors which are acceptable, what are behaviors which are non-acceptable, what are the forums in which a woman can complain of sexual harassment, and therefore what is the process that we follow. The confidence which people need to get that this policy is something which is serious, I think is a very, very critical part.
Even more critical in the unorganized sector. Asha Bajpai, Professor of Law at the Tata Institute of Social Sciences, says the initial challenge will be in communicating the existence of this law and its processes to the unorganized workforce.
For them, we'll have to do a campaign, an intense campaign. How we do, you remember the Pulse Polio campaign? Something like that, through mass media, through various, maybe make outreach very simple materials which can be disseminated through various community groups, through various microcredit organizations, through various what you call federations that are there for workers, unorganized workers. Trade unions could help in this.
In workplaces that employ less than 10 people and where the complaint is against the employer itself, a local complaints committee set up by district officers will address sexual harassment complaints. Women rights activist Flavia Agnes worries that these local committees may fall prey to bureaucratic and political control.
There will be a lot of competition. At the taluka level, the local politicians will dominate, the local political parties will dominate, or the local bureaucrats will dominate. I mean, there's no way anybody else from civil society will get into that. And even if somebody like trade union or other people do get into it, one cannot vouch for their sensitization. So that should be a role within the Ministry of Women and Child or Labour Ministry to get all the taluka level local complaints committees into a workshop to see and lay them guidelines that you have to do do's and don'ts. You must do this, you cannot do this, etc. And only then we can think something may emerge.
Any resistance to set up a committee can cost an employer a fine of up to 50,000 rupees, and repeated violations could lead to the cancellation of business license. The law gives the victim a 3-month window to complain, and the redressal rests on 2 C's: conciliation and compensation. The law entrusts complaints committees with the powers of a civil court, allowing for the examination of a person under oath and the discovery and production of documents. Based on the hearings, the committee can then suggest a conciliation and even order compensation. Though no conciliation process or compensation limits are prescribed in the law, the forthcoming rules may make that clear.
The very idea of a conciliation process in a sexual harassment case will create difficulties, because I remember the Family Courts Act, where conciliation is mandatory before any case goes to the court. Now what is happening in many family courts is that the conciliation many times becomes a compromise. If there are untrained counselors, conciliation doesn't achieve its objective. So we need to have professionally trained counselors for the conciliation process, so that it doesn't become some kind of a pressure tactic. It doesn't somehow try to tell a woman that no, you now settle. Settle should not be a compromise.
Sexual harassment is never about compensation. So that's one big no-no, because that's really not what a person is looking at if it's genuinely a sexual harassment case. What one is looking for is justice. One is wanting justice, and at the same time ensuring that there is an environment which is supporting them. So therefore they want the backing of the organization and the senior management to make it comfortable for them, whether it means a transfer out of the department to a location to another place, but basically they don't want to have to deal with this particular situation.
The new law does provide for such disciplinary action by a disciplinary committee, thus implying that the findings of the complaints committee are not final. That also means the victim and the accused could undergo a second cross-examination if the disciplinary committee so wants. The Supreme Court had ruled against this in the 2012 Medha Kotwal case, saying the disciplinary committee should act on the report of the complaints committee, but this new law ignores that judgment. It also leaves it up to the employers and their internal service rules to decide what disciplinary action to take.
Unless you are very specific in what is serious, what is the level of punishment which needs to be given for what kind of an act, I think the execution of this could fail. For example, at Infosys we have 4 levels which are defined very clearly in terms of saying that if somebody has been proved for doing action X, Y, Z, then a certain kind of severity would follow. And it is very, very important for all organizations and institutions to have the same level, because unless you have the same levels, you know, one organization would take it lightly depending on who the offender was, and another organization would take it seriously.
Disciplinary action is as far as this new law goes. The most severe punishment, and that being termination of service. For a victim seeking a harsher punishment, the only route available is the Indian Penal Code.
But the IPC has no specific sexual harassment section. In the past, victims have filed charges under sections 354 and 509 that deal with assault to outrage a woman's modesty or insulting the modesty of a woman.
The bill doesn't make sexual harassment a criminal offense. There are a lot of special enactments, like you have the SC/ST Act, which makes atrocities against the SC/ST sections a criminal offense. There are other special enactments. This special enactment does not make any such activity a criminal offense, number one. Number two, it says that no court will take any cognizance of any matter arising out of this bill. Therefore, on one hand, you do not make it an offense, and on the other hand, if there is any content of sexual harassment in a 354 IPC complaint case, until and unless the victim makes that complaint, there can be no police case before any magistrate for taking cognizance. Whereas that is the regular method of 354 complaints, that the police makes an investigation and lays the charge sheet before the magistrate for taking cognizance. Now that power has been taken away.
If you have a punishment of this or that category, which is to be decided by the complaints committee, which is in a way external to the internal process of disciplinary action, that might not have validity, and you might go to court and challenge it. So I think the whole purpose is to put it back into the machinery of the organization.
As far as criminal consequences of a sexual harassment matter is concerned, I feel that the law could have given a clearer guidelines, so that when the complaints committee refers the matter to the police is mandated to file a complaint, investigate it, and also take action.
Interestingly, this new law offers no protection to male victims of sexual harassment, though it does protect men from malicious complaints. If the complaints committee concludes that a complaint or the evidence is false, it can take action against the woman complainant. Though for that, the committee would need to establish malicious intent, and the lack of proof cannot become a ground for punishment.
There is one more safeguard, this one gender neutral, and has to do with confidentiality. The new law will be RTI proof. The details of the inquiry proceedings and the identity of the victim and the accused cannot be accessed via the Right to Information Act, and anyone who divulges this information can be penalized as well. That may be good for the victim, but that leaves employers with no means to access the past record of an employee. That said, I'd like to conclude by saying that more aspects of this new law or almost law will come to light by way of rules, and hopefully they'll fill in the gaps that the experts in this story have pointed out. In Mumbai, Paisani Upadhyay.
The question is, does this law represent a giant step for womankind in India? While critics point to the clause on false complaints, the limited 3-month period in which to make a complaint has some of the persistent negatives. I'd say the very setting up of committees is in question. Committees were prescribed by the Vishakha judgment as well, but hardly any exist today except in some evolved corporates. But I suppose we should be happy that after 15 long years, at least we have a law. On that note, let's take a quick break. On the other side, why the US Securities Exchange Commission, or the SEC, looks a lot like CSI Washington these days.